Yeah, another one on the back of the Letby case. Could the affected families sue the NHS or any individuals within the NHS? Okay, right, let's look at this. If you were to bring a claim, effectively it'd be claiming what we call negligence. Okay, and the test for negligence is somebody owes a duty of care to somebody, they breach that duty of care, and as a result of that breach of duty of care, there is a loss. Okay, so do they owe a duty of care? Probably we do what we call the proximity thing, or the neighbourhood sort of test, the neighbour who is my neighbour test. It's basically who might be affected by my actions. Like I say, the classic example is when you're driving, your duty of care to all other road users, because anything you do, your actions may affect other people. So in this particular case, people looking after young children, they must know that it's reasonably foreseeable that something goes wrong, it causes emotional harm to the families. And psychiatric harm, it's what we call nervous shock, actually. An old term. It can't just be general upset or anything like that. It's got to be something, quite severe. And of course, there are other losses. I mean, I know it sounds cynical, but there's things like funeral expenses and stuff like that. And there are general payouts for just the grief and suffering. Although that is capped, I'm not sure what it is at the moment. It used to be £7,500. That might have gone up now. But so okay, so you could probably show the duty of care, and obviously the loss. They can show a loss, but what's the breach? And they'd also have to show that the breach was the cause of the loss. So what's the breach? Well, negligence is falling below the standards you would expect of somebody in that position. And if you hold yourself out as professionals, you're held to slightly higher standards. I mean, say for instance, I offered to help you with some building work, and I cause an accident or something. Because I'm just helping you out, I could still be liable, but I won't be held to as high a standard as somebody who's like, you instruct a professional builder who's all sort of, PASMA qualified and knows all the health and safety stuff. So in this particular case, the staff would be held to, what's the standard we can reasonably expect from a person at this level with this level of experience and this level of responsibility. Um, so let's say they actually show that somebody did something that was a breach that fell well below that, and they'd have to show that that was causative of the loss. So they'd have to say but for your negligence, this couldn't have happened. She might have been stopped earlier or something like that. That's what you would have to show. I mean, if it was a case of, well, yes, you made like lots of mistakes, but actually it wouldn't have made a difference to the outcome, because even if you'd done it the right way, it would have still carried on. Then even though there's been a breach and you've suffered a loss and there's a duty of care, it doesn't amount to negligence, because there's a break in what we call causation. Okay. And that's something also people argue, in cases like this, to say, well, whatever I did wrong, ultimately somebody else did the deed. And therefore it's what we call an intervening act. We used to call it a novus actus interveniens. It's, basically, well, it doesn't matter what I did wrong, somebody else did something far worse. I mean, there's been cases about this where people have injured people, but then the ambulance has crashed. And basically they've said, well, all the actual injuries resulted from the ambulance crash. And then the argument is, well, yes, but for your action, we wouldn't have been in the ambulance in the first place. And, these all turn on, the actual factual matrix. But yeah, so we've got this. So let's say they can pin it on somebody. Well, do they sue the individual or the NHS or the NHS Trust, because they're separate organisations? We come on to something called vicarious responsibility. Generally speaking, if you are affected by the negligence of an employee, or an office holder of an organisation, and it's connected with their work, then you sue the organisation. The organisation is what we call vicariously liable. I mean, the principle behind that is they're more likely to have the money. I mean, there is a long history of this and what we call the master and servant rule and things like that. Because it used to be, the idea was, well, employees would be supervised by their master. So their master's ultimately responsible. But when society got more complex, I mean, your average hospital administrator probably doesn't know anything about neonatal care. So it's now more of a sort of like legal fiction. It's like, well, we don't expect you to actually have a be capable of keeping an eye personally on what's going on, but you should put systems in place to make sure that things are being done correctly, and that's your responsibility. So you've got that situation. But what's the definition of connected with work? It depends. It's not just the stuff, because obviously, employers will say, well, their work is to do their job properly, and therefore any breaches are outside their work contract, and any wrongdoing is outside the contract. Because let's say, when it comes to can they sue on the back of Letby herself, but like I say, it's anything that arises naturally from your work. I mean, to give an example, there's a case of a bus driver who assaulted a passenger because they got to a row about a fare and he punched him. And the passenger sued the bus company. And the argument was, well, was punching a passenger part of a bus driver's job? And they said, well, absolutely, obviously it's not in their contract. But the court held, yeah, but it is the sort of thing, you instruct bus drivers to do revenue enforcement, there's bound to be rows. So the fact that this could happen, even though technically, yes, he didn't do it and he's probably, is guilty of misconduct, it still arises out of his work. But obviously, cases have arisen when, if somebody's, just going out committing crimes, then they've said, that's not arising out of their work, even if, perhaps they're using work materials to do it. Let's say somebody, in the Wayne Couzens thing, will using the police badge. Because, the police would probably argue and say, well, that's outside, even though he used our stuff, that's outside, obviously, his work, and that's not, a part of his job or a logical consequence of his job or anything like that. And we'll probably get something here if they sue on the back of Letby. It'd be like, well, no, clearly, this is, gone beyond that. So this separates it from whatever we've done wrong. This separates it. So they would have to sue on, just the negligence for sort of allowing this to happen. But so that's the vicarious responsibility, liability aspect there. So yeah, I think bad decision making, even if very egregious bad decision making, will probably be found to be part, of their job, arising out of their job. So yeah, I think if they can find that, like I say, but if somebody's done something that's outside their, job, and they succeed in, the employer succeeds on the vicarious liability thing and says it's, we're not responsible, then you can go after the individual. But yeah, there you go. So yeah, there are, and undoubtedly there will be, threats of litigation about this. Chances are, I think actually, a prediction, they will settle. They'll probably wait till after the inquiry, you see. So, be like, right, we don't need a trial to establish what went wrong. There's going to be an inquiry. I've done the other video about whether it'll be a statutory or non-statutory, but they'll probably wait for that and say, okay, we can see what happened here, and, there'll be some sort of settlement behind the scenes. But anyway, yeah, if you found that useful or interesting, please consider clicking the like button, subscribing, and sharing.